May it please your lordship.
Yes.
Back to mention, my lord, this item number 9 and 10. These were anticipatory bail applications, my lord. Because of harassment by the police, we have filed it, anticipating harassment. But now I have been told, my lord, the accused person has been arrested. There is no question of harboring, and they don't want to press their matter anymore.
Accused person has been.
Yes, this was a case, my lord. This is the sister of a accused person who was accused of, my lord, the incident in rowing, where this one person was beaten to death. There was the allegation.
Okay.
The drawing. So the accused person was not surrendering. The police also could not catch him. So, my lord, just to pressurize him, the elder sister's name was brought in just for harboring 212 and all. So there, after this, my lord, we got interim protection. Also, we appeared. We were not even arrested. No statements also was taken. The accused person in the meantime surrendered.
Okay.
So we are withdrawing. I have instruction to withdraw, my lord.
Want to withdraw. Okay.
9 and 10.
Okay. Land Council for the petitioner, Mr. Dicky Pange, want to withdraw this bail application. This this AB bail application is dismissed on being withdrawn. Okay.
10 also. Item 10 also.
Item 10 also.
Yes.
Similar. Okay.
May I please?
Yes.
Lordship, I beg to mention item number 15, and I am appearing for the respondent number 2, Lordship. Lordship, today we are supposed to file affidavit in reply, but Lordship, the same is not completed, Lordship. So
Have you informed the
yes,
petitioner?
yes, Lordship. I have taken the consent.
I'm body petitioner.
You want to file
Affidavit in
opposition?
yes. Lordship.
Okay, Mr.
N. Kumar. N. Kumar.
N. Kumar, Land Council for the respondent number 2.
2. Yes.
With the consent of the Land Council for the petitioner. Praise for listing this matter after 2 weeks,
After Lordship, after
after summer vacation.
yes, Lordship.
Your Honor,
And
there's
in the meantime, he would, so that in the meantime, he would file affidavit in opposition. The prayer is allowed. List this matter after the
my
summer
lord,
vacation.
interim protection. There is interim protection in this.
You are in which?
Petitioner.
Oh, you are for the petitioner.
Yes, Lord.
Okay. You are Mr.
Tipahi,
Land Council for the petitioner, Mr.
Tempahi.
He is present. Stop. Then you write Mr. His name, Land Council for the respondent number 2. Praise for further. Praise for some more time to file affidavit in opposition. Stop. Affidavit in opposition to which the Land Council for the petitioner has no objection. Accordingly, the prayer is allowed. List this matter after summer vacation. Stop. The interim order passed earlier shall continue till the next stage. Okay. Oblige. Yes.
Your Honor, I would like to mention item number 12 and 20.
12 and
20.
12.
Yes, Your Honor.
In 12, you
12.
are for
For applicant.
appellant.
Yeah.
Petitioner.
Yes, Your Honor. And Your Honor, matter may be listed day after tomorrow.
Why?
Because main council is out of session. And Your Honor,
Day
item
after
number,
tomorrow.
yes, Your Honor.
Day after tomorrow is Friday. No, not on Friday.
Item number 12, Your Lordship. There is an interim, already interim has been granted to them. So there is no urgency as such. So this may be listed after vacation.
After vacation.
Yes.
Okay. You are Mr.
C. Peter.
C.
Peter. Behalf of
Submits that the conducting council is out of stations and prays for listing this matter after vacation. The prayer is allowed. List this matter after vacation.
Deeply obliged.
Interim is there.
Interim is
What
there.
type of interim?
Your Lordship, it's a joint petition, Your Lordship, on settlement by the parties The section involved is section 457, 427,
So
380.
the proceeding has
Yes,
been
it
stayed.
stayed.
Okay.
It
The
was
interim
stayed.
order passed earlier shall continue till the next day. Okay.
Obliged, Your Lordship.
And your Honor, item number 20.
20. In 20, you are for
Affiliate, Your Honor.
appellant.
Yes, Your Honor. And I have informed other opposite person, party also,
Okay. Mr.
after 2 months.
Okay, his name, Mr. Huh? Submit says the conducting council is out of station, hence pray for listing this matter after vacation. Have you informed the other side?
Yes, Your Honor.
Okay. The land council, Father Sami said he has already informed the other side and taken consent from the land council of the other side. Stop. The prayer is allowed. List this matter after the vacation. After the ensuing vacation. Okay.
May, my lord.
Yeah.
My lord, I beg to mention item number 17.
Yes.
My lord, council is out of station due to some personal difficulties. With
You are
the, I'm for the petitioner on behalf of K lawyer.
Petitioner.
Yes. With consent
Yes.
from
Have
other
you
side.
informed the other side?
Yes, my lord.
Okay. You are Mr.
Mr. T Mite, MITE.
Okay. Sami says the conducting council is out of station.
My lord,
Due to which
matter
what?
may be list after summer vacation.
Okay. The conducting council could not appear today due to his personal difficulties, hence pray for listing this matter after the summer vacation. The council also submits that he has also obtained consent from the land council from the other side. Accordingly, the prayer is allowed. List this matter after the ensuing summer vacation. Okay.
Much obliged.
Your Lordship, I beg to mention item number 19.
Yes.
Lordship, conducting counsel for the matter is out of station
Okay, Miss,
in Hondi.
you are for the petitioner?
Yes,
The
Your Lordship.
appellant?
Yes, Lordship.
Okay, land council. Submits that the conducting council is out of station, hence pray for listing this matter after
After vacation, Lordship.
after vacation. Okay, the prayer is allowed. List this matter after vacation. Okay,
Deeply obliged. I'm state for in this matter, Lordship.
Hmm?
I'm for state in this
okay,
matter.
Miss L. Again, land additional PP appears on behalf of the state. Okay,
Obliged.
May I please, Your Lordship?
yes,
Your Lordship, I beg to mention item number 18, Your Lordship.
okay,
Your
you are
Lordship.
for
For respondent, Your Lordship.
respondent. What do you want?
Your Lordship may kindly, matter may be fixed on 18 of July, Your Lordship.
18.
Yes, Your Lordship.
You are for respondent.
Yes, Your Lordship. And
Who is for the petitioner?
I've taken consent.
On 18. 18 July. Okay. On the joint prayer made by the Lana Council for the parties, list this matter on 18 July.
Much obliged.
Mayor, my lord.
Yeah.
I would like to mention item number 11.
11.
Yes.
Yes.
Here, the leading counsel, Mr. Jejin, is engaged in some personal work, so he could not appear today, my lord. Can it be after vacation, immediately after vacation?
Okay. You are for the appellant only?
Yes.
Okay. As prayed for by Mr. Binder Picha, Lana Council for the appellant. List this matter after
Immediately after vacation.
vacation.
Yes, ma'am.
Okay.
Obliged, ma'am.
Okay, just a minute. Mr. Ojing Pada Lana Council for the respondent is also present in that case. Okay. Yes. 21.
My lord, this bail application has been filed under section 439 CRPC, my lord. Praying for the enlargement of one of the alleged accused, Sri Amit Kumar Thakur, who has been arrested on 24/1/2024 and is presently under detainment, my lord, for last, I think, for 154 days. So, my lord, there is no no chance for him to hamper or tamper with the case, my lord. He has been cooperative since the beginning. And when he learned that a case has been registered against him, he promptly surrendered himself before the police station, my lord. And since then, he is under detainment.
He was arrested on,
24/1/2024.
what happened to the case? Case charge sheeted?
Yes, my lord, charge sheet has been completed. And 164 of the victim A and B is also completed, my lord.
164?
Yes, my lord.
So if the charge sheet already filed, then whether the charge has been framed,
No charge, it's, my lord, in the, charge will be framed very soon, my lord. It's about to be framed,
not yet framed.
not yet framed, my lord.
Mr. Can call for, then
Notice to
whether,
the,
notice.
notice to the informant.
Whether if the charge case has already been charge sheeted, whether has it been registered in the trial court? Hmm? Have you
Yes,
mentioned the
Yes, my lord.
trial court number? Where? Whether the court has taken cognizance? It is before the POCSO Act only.
Yes, ma'am.
Yes, my lord.
Okay. So have you mentioned the number? Where?
Charge sheet
Where do we
number,
find?
my lord.
Because CD we cannot, if the case has already been charge sheeted, CD we cannot call. It is before the court only. So where
Yes.
is, have you mentioned the case number of the court? There's no case number. POCSO case number.
Yes, my lord.
You said that case has already been charge sheeted. It is before the court only. Petitioner, this is matter on. When can you collect today? Tomorrow, full list. Or when can, where, which
Um,
court?
Special court.
Special
POCSO.
court FOCSO, my lord.
UPM.
UPI.
UPR.
My lord, day after tomorrow, my lord.
Day after tomorrow.
Yes, my lord.
Is prayed for by the Lana Council for the petitioner. List is matter on. Day after tomorrow is 20. Okay, 28. Okay.
Deeply obliged.
Yes.
My lordship. Lordship, this is a joint petition filed under section 482 for quashing the FIR in connection of Bandadeva PS case 3023.
Yes.
Your lordship, matter has already been resolved among the parties.
So what?
So, your lordship, petitioner number 1 wants to withdraw the FIR.
Can't. What is the offense involved?
Under section 380 IPC.
What? Let us see the FIR.
FIR is in page number 15.
Okay. Where is the settlement?
Settlement agreement.
This is stealing of gas cylinder.
Yes, gas cylinder. But all the stolen property has been recovered by the petitioner number 1 on Zimma.
Recovered by the owner,
Yes, owner.
not by the police.
By the police, but they have been given the items on Zimma.
Handed it over back to the owner.
Yes.
Okay. Where is the agreement?
Agreement is at page 41.
Yes.
And your lordship, the matter is already, the matter is
When the
already,
incident took place,
incident was took place
12/8. And then when this agreement entered,
22 June.
after completion of the investigation.
Yes. Your lordship, the matter is pending before the JMFC court, UPR.
Whether the charge has already been.
Charge has already been framed and it is in evidence stage.
Then, so charge framed only after hearing the parties.
Yes, evidence is, it is in the evidence stage. And
Then-
already the petitioner number 1, who is the informant in this case, has already been, his
Examined.
statement has already been recorded. And he does not want to pursue the case.
No, he don't have to pursue now. He has
No,
already been
in
examined.
the statement, yes, statement he does not, he want to withdraw
Then
the
he
FIR.
must have cooperated.
Yes, he want to,
There's no case, no more case. He will automatically, he will discharge only,
But-
acquitted, since he, evidence has already been recorded.
only one,
Then get the acquittal order, that is better.
no, it's a non-compoundable, so that only the one witness has been examined. It's only the informant itself.
That is enough, because the allegation was made by the informant only. He has given evidence, which is no evidence against the accused. Then automatically he will be acquitted only.
Now, your lordship, if I may, your lordship, clarify to that effect,
Yes.
your lordship. Under 482, your lordship can at any stage quash the proceeding, your lordship.
Please.
Now, in this case, what has happened is PW1, that is the complainant, has given his statement, your lordship. Even if he has given against the accused, your lordship. Meanwhile, if they comes to an agreement, the agreement should consist of the factors that the stolen properties were recovered, he was compensated and all, and there is no further interest of the party to pursue the case. That is also to be taken consideration. The important factor that is to be considered is how the section that the accused is charged of, your lordship, how severe and serious
Is
is
it
it
going
in
to
nature?
affect the
It's only,
society at large?
yes. And more particularly, if it's a private offense or a public offense, your lordship.
Involved with affecting the
Public at
private
large.
party only.
Yes, private party. In the event of
How many
any,
accused persons? Only one,
there are two. Petitioner number 2 and 3.
2 and 3.
Yes.
So whether
Now-
the record need to be called?
No, your lordship, if I may bring your lordship to the page number 40, your lordship. Which is the order of this, the JMFC court, your lordship, where the matter has been adjourned for 2 months of considering the fact that the parties wanted to approach the Honorable High Court for quashing of the case, your lordship. Even calling upon the case, the record would not be much of necessary, your lordship.
Okay, so the magistrate indicated they approached the High Court. for-
Yes,
Since
yes, Lord. So it
Okay.
has been,
Since it-
adjourned for a very long time. Even otherwise, your lordship, the only section that is in this case is of 380, your lordship.
Hmm?
380, your lordship.
380.
All these stolen items were returned, your lordship, and those that were not returned has been compensated as per the agreement, your lordship.
As per the, what
Agreement 41,
way? Agreement is
41, your lordship. Now, your lordship will start from now these deed witnesses as follows.
Witnesses.
As follows, your lordship.
So the informant has given pardon.
Yes. The recovered items as per the seizure list is the mobile phone and the gas cylinder, Your Lordship. The other two items is of the pipe and the machine, cutting machine. Since as per the agreement, Your Lordship, settlement, Your
Item-
Lordship.
The item is mentioned here.
No, Your Lordship, the seizure list contains the items that has been seized back, and it was given on Zimma to the the
So
informant.
all the lost item has been found.
Yes, mobile and cylinder has been found, and the machine and the pipes, they could not be recovered, but then the accused has compensated with
Adequately.
regard to that item.
So that means they can be disposed of.
Yes, Your Lordship, because calling off the GCR, not necessary.
Miss
Why Dagyam?
Dagyam, line counsel for the petition. Also her Miss T. Jeannie, line additional public prosecutor for the state of Arunachal Pradesh staff. Para. This is an application under section 482 of the Code of Criminal Procedure 1973, praying for quashing and setting aside the BDW PS case number 32/23 under section 380 of IPC. Arising, no, just a minute.
Your Lordship, if the
No, just a minute, Crossing of GR number 6389/2023 arising out of the BWD Bandadwa PS case number 32/23 IP 23 under section 380 IPC. Stop. The brief fact of the case is that on 12/18/2023,
12/8.
the 12/8, it's 8/2023. The informant is petitioner number,
1. It is the number 1.
the petitioner number 1. Informant laws a written FIR. Sorry, laws FIR for missing. Laws a missing complaint. Stating there in that. On 4/8/2023 at around 2 a.m. to 3 p.m. 3 a.m. some unknown miscreant entered illegally at construction site located at Kasinsa Tea Garden and stolen away some items including gas cylinder, water pump, motor, road cutting machine, mobile handset, and press for taking necessary action. Stop. Basing on the above written missing complaint, a case was registered being Bandadwa PS case number 32/2023 under section 380 IPC and IPC and investigated into. Stop. during it is submitted that during the course of investigation, the lost item, lost article has been recovered, seized, and thereafter the same has been handed over back to the informant. And after completion of the investigation, the case has been submitted into charge sheet before the land court of the charge sheet staff. Have you collected the evidence evidence adduced by the informant? Since you say that
No,
already,
only the court, only the order of the Honorable JMFC Court.
no, you say that the evidence of the informant has already been recorded.
Yes.
Have you collected the evidence recorded by the JMFC?
No, only the not recorded. It was passed an order, page number 40. It was Honorable JMFC order.
No, here he stated that he don't want to pursue the matter. You said
Do-
that evidence already recorded.
Your Lordship, during the stage of he submitted that he does not want to pursue the case. So
Evidence was not
evidence was
recorded.
not recorded.
So then, it is submitted that in the meantime, the case has amicably been settled between the parties. By executing a settlement agreement. On 22/6/2024. So, in the said agreement, said settlement agreement, the petitioner number 1 is the,
Informant.
okay. Okay, the said agreement among other contain that the petitioner number 2 and 3 who are accused in the above GR case number 639/2023 has returned the materials, return the articles. The lost article belong to the petitioner number 1. It is also the petitioner number 1, semicolon. The petitioner number 2 and 3 has also compensated for the article which could not be recovered Which was the article which was not recovered?
The hand,
Water pump motor,
Okay,
road cutting
which
machine.
was not recovered, like water pump, huh?
motor and road cutting machine.
And road cutting machine stuff. Huh? On receipt of the above lost article, the petitioner number 1 has forgiven the petitioner number 2 and 3 and since he has no further grievances against the petitioner number 2 and 3, the petitioner number 2 has undertaken, one has undertaken to withdraw the case against the petitioner number 2 and 3. Stop. Accordingly, the petitioner number, the petitioner number 1 approached the learned trial court and expressed that he did not, since the matter has settled between the parties and he has no further grievances against the petitioner number 2 and 3, he may be allowed to withdraw the case. However, by an order dated 5/6/2024, the learned JMFC observed that since the offense against the accused within bracket petitioner number 1 and 2 and 3, that is section 380 of IPC is non-compoundable in nature. And accordingly, the informant petitioner number 1 has been advised to approach the higher court. Enhance this application. For praying for washing and setting aside the setting aside the GR case number 639. Is there any other submission other than that?
No, Your Lordship.
Okay. So what will do the conclusion part? I'll
Yes.
pass on.
Deeply.
So
Obliged.
this will complete. Yes.
May it please your lordship. Lordship, we should also adjourn plan under 480. Their offenses are only one offense, this is 279, which has a 6-month maximum punishment. Is a non-compoundable, and rest 338 is a compoundable. And already both the parties have amicably settled, and charge sheet has also been filed, and the case is before the learned JMFC court. It's fixed on 1st July for
Just let us see the, this is complaint.
Complaint was lodged on
For what? Laws on 14.
2017 matter.
2017 matter. It was filed on the 14/12/2017.
14/12/2017. Let us read the FIR. Just What is the thing stolen?
So the officer in charge
Last night.
complaint against the Scorpio owner who last night driving race and negligently tried to kill.
Okay, negligent driving. Yes. Yes.
Negligent tried to kill me near Rajiv Gandhi Bhavan. Sir, with due respect, most humble and respectfully, I have honor to inform you that today I have submitted my application for seeking justice because last night I am coming from 6 miles to return my house. But in the meantime, one Scorpio being registration number AR019777 coming from opposite direction to hit my scooty and try to kill me. The Scorpio driver never stopped. That incident place and he carried my scooty long way near Rajiv Gandhi Bhavan to near Anticipatory office at around 10 p.m. Due to the race and negligent driving of the opposite party, without any fault on the part of my side, the vehicle which was turned over me. As a matter of fact, the incident happened on 13/12/2017. So I am completely injured and my leg also not working and several injured in my whole body. Why that Scorpio driver not stop the incident place and why they are not admit me near a hospital at that time? I'm completely unconscious. That is why I submit my application properly. This is a complete race and negligence case. At least 200 meters, the said Scorpio driver carry my scooty and he tried to escape himself. So I kindly register my case because he tried to kill me last night. That is why he.
Okay, so thereafter case. After that, case was registered.
Yes, Your Lord.
And then when the charge sheet filed
Charge sheet was filed on
on a section,
under section 279 and 330.
same, 279 and
338 IPC.
338,
338 IPC.
330,
38.
where?
427 as well.
337.
Page
I
22.
could see page 22.
22, Your Lordship.
What is 337? The punishment?
It's a compoundable offense, Your Lordship.
It's compoundable.
Yes, Your Lordship.
Okay, 427 compoundable.
Only 279 is non-compoundable.
279 not compoundable.
Yes, Your Lordship.
Okay. Charge sheet filed.
Charge sheet filed.
Trial begun.
Now trial is fixed for appearance on 1st July.
Well, you have annexed the order also.
I have not annexed fixed on one.
Where have you stated that it is next date fixed? For what? Next date is fixed for what?
For appearance.
For appearance only. First time appearance.
Earlier also once date was.
The case is of 2017.
2007.
Okay.
Taking cases, Your Lordship.
Okay, just a minute.
for admitted
Where have you mentioned the case number of the trial court? Which court?
Lamed JMFC court.
JMFC Itanagar. Okay. So where is the settlement?
Settlement agreement is on page 42, Your Lordship, annexure 3.
Page
41.
4.
Page 41 and 42.
42. What is the settlement says?
Settlement, it says that they have.
Para?
There is no para, the first paragraph, the first party and second party have mutually and amicably settled the above case.
Okay, then any compensation, anything compensated?
Compensation and new scooty was given way back.
Where do we find?
It was not stated, but Your Lordship already.
No, here in the agreement, in the case settlement, what is the content?
Sub para, Your Lordship, may see para 4, Your Lordship. The first party and the second party.
Mutually amicably settled.
Above, thereafter date of incident, the first party had already settled the matter with the second party and had paid for his medical expenses and his scooty. That both the parties at the time has already resolved the matter.
From
Already
2007.
resolved, okay.
And after
Second
that,
party
Your Lordship,
wrote
yes.
so second party. Was
Is
the
the
fire, and the both parties also, both are relative also,
Yes, sir, they are related.
for the second party. No more difference.
Reason behind was that he could not stop from at the time of incident, because there was lots of crowds gathering. They started packing stone and apparently saying that. So he went away. After a few days, he went and he came and inquired about the victim. And he was found in the hospital and he compensated all the medical expenses. Even a new scooty was being purchased for the complainant.
So you have anything?
No objection, your lordship.
Records may also not be necessary.
Not
Hearing
required,
is
your
closed.
lordship. Yes, on oath, they are they
Can
have
pass
affidavit,
order?
they have respective affidavit has been filed, then this court can dispose of the matter, your lordship, considering this
Okay.
the conditions.
Or Mr. A. Bhattacharjee, Land Counsel for the petitioner. I've also heard Mr. Ete, Land Additional Public Prosecutor. I'll dispose of.
Deeply obliged, your lordship.
Dispose. Chamber. Yes.
24 is bail. 24. If my lord may kindly accommodate us, just small item 24.
24.
Only 2 minutes it will take.
24. Okay.
Yes.
Both the parties are ready.
Yes.
Okay. So,
No, this poor fellow is behind the bar. We call it as incarceration for 41 days. In connection with that case, my lord.
Hmm?
The fraudulent teacher recruitment that is
Okay.
key that is going on. And then, my lord, since the day of detention, has been in the jail and then has been cooperating with the investigations. And also, my lord, the investigating the IO of the SIC has not sought for any custodial interrogation, my lord. 41 days, and then my lord will kindly come to para 11, page 13, on a similar situated, on the same set of facts and issues, and the FIR bails have been granted, my lord.
Bail granted to
Other co-accused, my lord.
page, you said?
Main accused also, page 13, my lord. Para 11, I have made a mention of those. Huh? Yes. The main accused has also been granted bail, my lord. That it is, my lord, has it, page 13, 1, 3, on the bail. That it is pertinent that it is pertaining to illegal appointment of teachers and MTS on the elementary education department of government of Arunachal. So for 12 FIRs have been raised. I am connected with 8, my lord. FIR number 8.
FIR number 8.
8 have been registered by the SIC police station Ranagar, so and so, read with so and so, so and so. In all the cases, the prime accused so and so, then director Itanagar has been granted bail by this honorable court, which was registered as so and so. So these are the series of bail granted. But only in the bail jurisprudence, right from Satyendra until, and that.
Have you, or do you have the copy of the bail granted to the main accused?
Below. It is there? Yes, madam, my younger says it is here. 24/8/2023. And
So here is same case.
same case.
He is the main accused.
The director is the main accused.
So he probably he was granted on medical ground only, it appears.
Yes. Well,
Okay, so
which is the main one? This. Yeah, that is the.
cardiology
Yes.
department,
Well, this gentleman was engaged by one office clerk to assist him in typing out the documents in the MS Word. And then he get in touch with this gentleman, the director, main accused.
he was also used. And later on, the allegation is that he successfully forged the document, seeking, in securing an appointment for himself as PGT, and also his wife and another one. So now the question is, whether custodial interrogation is required or not. And if whether the question now is, if the custodial interrogation is not required,
This
can,
is AB, this is AB. huh?
yeah.
Considering is on
Oh,
health ground.
Where is that original law?
So this is,
This is one.
this is the case, I think.
But
different
this
case.
is accounting. 410.
The instant case, the accused has already been arrested.
Arrested already.
So this is regular
Yeah,
bail.
this is regular bail. I am in incarceration for 41 days. Today is what, second?
No, 43 days.
No, 42. It will be 42 days. That
15 minutes. On the clear minute.
May.
This is also in the same case.
Yes, same.
This is the main,
They are the main accused.
regular bail.
Yes.
This was after. How many days, for how long this? In the BA 94, the accused was inside the custody?
In my case, Malak,
No, in the.
This,
case of
well,
this
I have
94
not-
Which we
I
have
have not
just
seen.
presented.
And I am not aware of.
Okay,
But substantially, Malak. This is also Malak 41 days, 42 days now. Malak, that
what is your name? The name of the accused here?
Bombay Mulam. Malak.
No,
The name of the accused is June Lendo. Mixer Gulam Elas, June Lendo, and the wife is the applicant. Huh? Cousin brother is the applicant.
Oh,
Well, if my brother says something, whether the custodial interrogation is required.
in the same case, what is the case against the president?
Well,
accused?
he was working in a contingency in the.
The present
establishment-
accused?
Yes, madam, in the DD office, madam, in the Director Education Office, madam. So what he did, madam, he gave around 3 lakhs to the then director, the main accused, for appointing.
Main accused who was, who is it, who is protected by this
Yes, yes, madam, interim order, madam.
interim?
In total, madam, 13 cases were registered, madam, in regard to the illegal appointment of teachers, madam, in the whole,
Against this same,
no, in the whole state, madam.
okay,
13 cases, madam, in all those.
1-3,
1-3.
okay.
In all those cases, the main accused, the then director.
In some cases, he obtained AB,
No,
interim,
yes, yes.
in all cases.
In 2 cases, he was given regular bail. And in 11 cases, he has been granted interim protection. That has been health grounds, obviously. But that has been made absolute as of now.
Made
So,
absolute.
yes, yes. So he is on bail now,
Hmm.
the main accused. Now, as far as this present petitioner is concerned, my lord, he was working in the DD department as a contingency. So he paid 3 lakhs to the then director for getting his wife appointed
Illegal.
as PRT in Lower Siang district. There is this present case, my lord. SSC case number 8 of 2024. 8 of 2024, my lord. So in connection with that case, he has been arrested, my lord. And the other, there is another case which has been registered against him. There is of SSC PS case 05 of 2024, which pertains to Teju, my lord, Lohit district, where he has obtained appointment for himself by forging the signature of the
Same accused.
same accused. But in that case, he has not been arrested, my lord. In that case, what he did, he forged the signature of the director. But yes, and then what he did, he got appointment, but then he did not, join the establishment. because of fear, because by that time, all these schemes, yeah, it came out. So he did not. But fairly submitting, my lord, as of
My lord,
that, obviously, my lord, we have thoroughly investigated this person. He has revealed everything. He's cooperating with the investigation, my lord. And
that's
he's
the end
been
of the matter, my lord.
in the custody for the last 42 days. So today will be the 42nd day.
So what is your submission?
His custodial may not be necessary as of now.
That's it.
Because he is cooperating with the investigation.
My lord will only record one thing. If he is not required in any other case.
No,
That would be why? Because he is also an accused in a.
in the release order itself, it is.
Yes,
Correct. Tomorrow I will have some long time in one bail matter in this court. My lord, they have to accommodate me.
You have to just.
The series, my lord. The statement, my lord, will find at page 54, my lord.
Page?
54.
Hello.
Probably.
Page 54 is the statement, 161 statement of the accused.
Which is statement?
Yes, my lord.
Okay. Statement.
Yes.
And so he has.
He has admitted, my lord. If my lord turn to page 55, my lord, down below, my lord. The last para.
Yeah.
Yeah, the last one. My lord, may see the answer, my lord. The question.
In the same page.
Yes, yes. Page 55, my lord. He admits that he has paid 3 lakhs to the then director.
In the answer to the last question.
Yes, my lord. Page 55.
I also have the same instruction from the client's family that during course of interrogation, he has admitted the crime that he has committed.
Okay. So the wife also.
Yes, I got that information.
But where is the status report?
The status, my lord, will find it in the first page, my lord. Is the status. The first
Where
page.
will we find that?
Yes, the first page. It's
second page.
First, page 1 to 3, my lord, is the status report, my lord.
The status.
Yes, my lord.
Okay. What is the opinion of the IO of the case? Comment?
Comment, my lord, at page 3, my lord. Para 11, my lord.
So it's praying for rejection.
Yes, my lord.
First part, they say that, my lord, cooperating with the investigation, my brother has submitted and nothing is to be recovered. And then, my lord, that doctrine of parity will come. I will not rely on anything, my lord.
No. So we have to see on what ground main accused. Main accused probably not on merit.
Yeah, main accused are released only on health grounds, man.
Only on health grounds.
Health grounds, man.
So probably the parity, the question of parity.
Parity might
come.
not arise, man.
Accountant, well, but there is one this thing that accountant one which is the second Wangsa was on merit, on the fact that no custodial interrogation is required.
No, in this case, the IO has not indicated we want him inside custody till completion of investigation. Since by the way, when the FIR was lodged here in this case?
FIR, my lord.
It's a very, my lord, on
10th
the
of
basis,
January, my lord.
on the basis of
10th of January.
10 January.
January.
And subsequently it was registered on 6/2/2024.
Investigation not yet completed.
No, my lord, because in total there are 13 cases like in the whole state, my lord. And we have segregated all those cases into district-wise, my lord.
So what about the other accused, the wife was also arrested?
No, wife has
No,
not
no.
been arrested, ma'am.
Okay,
She has been terminated from the service, ma'am, but then
Okay.
she has not been arrested, ma'am.
what about the other co-accused?
Main
How many accused?
accused,
Here in this case, how many accused?
Here, my lord will find. In this case, only two persons, my lord. The then DDSC, he was already released on bail, and this present,
Only two,
only two, my lord.
no other.
No other accused has been
Nothing
arrested,
more.
my lord.
Because, my
In
lord,
total, there are six.
So these for two accused persons,
Yes.
one separate case has been registered.
No, it's total six, my lord, because out of these three, the first one is the then director, the second is the DDSC, the then DDSC, the third accused is the wife, who is a candidate. So, and the other accused persons, they are also candidates, my lord.
Okay, what about the other candidates?
No, they have not been arrested, my lord. They have
Not been arrested?
Not been arrested, my lord.
but I have no connection,
Has it been reflected here in the status of IO?
because in other, my lord, I have no connections, except for this, three people.
To go through at least the status
My lord.
for passing.
Yes.
So after two, let us say.
My lord, I'm leaving, my lord.
Yes, yes,
My lord.
no problem, you're junior there.
Uh,
To just to assist. I
Okay.
just need to see, can't assure now, at the moment. Oh, yes, why, not to go, I just wanted to go through the records with the help of Lanet special PP only. Hmm. Hmm. That's a serious allegation. Hmm. And admitted. Okay. Ah. Hmm. 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 Hmm.
But these does not come under the classifications of the economic office. Economic office, you know, basically is something that you have lost deliberately or intentionally, you have caused loss to the state, gone out of the consolidated fund of India. Here is a case, nothing but forgery. Then only a forgery, and forgery, you know, Article 78 is the most,
So in the admitted position, then he is likely to be convicted.
no.
Hmm.
The police has only 90 days.
Hmm.
And my is also aware,
Hmm.
in the decisions by the appeals court and this court also, that once it's state,
Hmm.
it's not as
Whether the accused has been forwarded to the Land Judicial Magistrate First Class for Judicial Magistrate for recording his confessional statement, since he himself has disclosed and admitted, not forwarded. Okay.
So therefore, even 164 also, these are nothing but corroborations of corroborative in nature. So therefore, it cannot be considered as a Now, the larger question comes for this court. In view of the admission of the fact, whether a fair opportunity should be given to the accused to sense the hostile information to the state. Number one. And number two, right from the real case versus the state of Punjab 1950, where the bail jurisprudence was developed. There it says bail. Now there was on the facet of the Magna Carta, where it says personal life and liberty, and that has been attributed, dividing our constitutions from the British constitutions. So there were, that personal liberty and expression. That is why before Article 21 of the Constitution and Article 19 of the Constitution comes in. Say, another argument would be that if, suppose for some reasons, some innocent people are arrested on mere suspicion, then his personal reputation, life and liberty is at top. Till such time he gets the relief from the court. So in the period, in the bare jurisprudence, I bring up the argument. Only three things I want to see: whether the personal life and liberty of the individual is protected. That is the basic objective of a bare jurisprudence. The second is that whether his release would mean would hamper and damper with the incumbrances of the other court. Here only, the FIR is in respect of the 6 people below. The first is the director, who is on the base of the various
cases, my lord. Secondly, my lord, is myself for doing 2 things, my lord. What are these 2 things? The first thing is that I have forged the signature and fraudulently got myself appointed as PGT, my lord. That is one. Secondly, my lord, yes, I have given 3 lakhs to then director for getting appointment of another 3 persons. Now, my lord, 4 persons are not being arrested. Out of 6 accused, 4 has not been arrested. 1 is on the bail. Then another is me, who is behind the incarceration for last 42 days, my lord. My lord, therefore, my lord, I don't know, I am not privy to the case diary and the status report. Normally, my lord, police will write, my lord, the IO of the case, my lord, will always write in the conclusion line that bail may be rejected till completion of the investigation. Really, that does mean a blanket check to the IO to always oppose the grant of the bail. Does not that mean that that particular sentence, my lord, is against the objective of Article 21 of the Constitution? And my lord, that Wangsa judgment, where is that? My lord, the Germany of the entire corruption, my lord, in this case started from this Changlang district only, my lord.
This is a
Londing, sorry, my lord. Londing. This is Londing, my lord. This particular is the accountant. Accountant, right? This particular gentleman, the accused was working as an accountant.
in BA 94.
Yeah, yes, my lord, in BA 94. And he was granted, my lord. This, it is by Lordship Nani only. There was a confessional statement or not. My lord will kindly come to internal page 5. Last
bail
paragraph.
application.
Yes, my lord.
Bail order.
Yes, my lord. Detailed facts, we did not to do this, my lord.
Yes.
On consideration of the matter in its entirety, if the custody of the accused, Sri Jomdo Lona, the former DDSC Londing, who was arrested on 27/7/23, is no longer required by the IO, as can be gathered from the fact that the IO had not raised any objection on the bail application filed for release of accused Jomdo Lona in the order dated so-and-so, passed by learned so-and-so in bail application in connection with SIC case number 2, my lord. This is the Germany of the whole case, my lord. So therefore, my lord, even...
But here is the case where the IO has raised objection.
No, that's why, my lord, kindly peruse the case very last sentence. Only if the IO has made a statement that bail may be rejected till completion of the investigation. Now here is 6%, my lord. In this particular case, there are 6 people. 4 of them are the beneficiary of the proceed of the crime, and 2 main accused. The director, my lord, I am a mere contract LDC there. I don't have privy to the file, my lord. So therefore, when the main accused itself is on the bail.
Against this accused.
Yes,
So
main
for
accused.
forgery also, I think he has been. The
Well-
offense under forgery also registered against him.
No, my lord, that is another case. That's why, my lord.
The
But-
forgery is another case.
No, that forgery,
Same only.
same.
Hmm.
But suppose, my lord, in this particular case,
Yes.
whether, see, my lord, what happens under Section 65B of the Evidence Act, my lord, what happens that electronic, whether certification is required, whether the signature has been forged or not. Once the expert opinion of the electronic records that read with section 2(1) of the Information Technology Act 2000, my lord.
Say that he is admitted that, he admitted.
That's what, my lord, I'm saying. In view of that admission, my lord will infer in a positive way. That means his custodial interrogation is at all not required because there is nothing to be recovered from him, my lord. So therefore, my lord, kindly allow these bail applications. Even the learned special public prosecutor has also categorically made a submission this morning saying that he is cooperating with the investigation. So that count, my lord, kindly respect the objective of Article 21, my lord. Although bail application is nothing but, my lord, is a euthanasia, a mercy petition only, my lord, because this is a discretion to be exercised by the lordship. Now, lordship, kindly see 439, my lord. Then these, my lord, the culmination is, my lord, 437 clause 3, my lord. Kindly have this 437 clause 3, my lord.
Yes.
Well, the 437 is the actual thing, my lord, for consideration of the bail. Clause 3 kindly come, my lord.
Yes.
When a person accused or suspected of the commission of an offense punishable with the imprisonment which may extend to 7 years or more of an offense under Chapter 6, Chapter 16 or Chapter 17 of Indian Penal Code or abatement of or conspiracy or attempt to commit any such offense is released on bail under subsection 1, the court shall impose following conditions. Now kindly come to 1, such a person shall, my lord. The 437, my lord, will come back for a moment. When any person accused of or suspected of the commission of any non-bailable offense is arrested or detained without warrant, my lord, here, kindly mark one thing, my lord. I don't want to place this judgment because I am going to rely tomorrow, my lord. There is, my lord, any detention, my lord. Here in Arunachal, my lord, there is one trained by the police. Law says the requirement under law is that you must give in writing the reason of arrest. Here they are not giving it, my lord. Law is well settled. I am coming tomorrow, my lord, for a particular case. I'll demonstrate this. Kindly see, my lord, in their arrest memo, my lord. Has they given any written intimation to the accused? No. If the written reason of detention is not given, the detention is illegal. And apex court in one of the landmark judgment has set aside the arrest, my lord. Secondly, my lord, there is a word suspicion in 437, my lord. The word 437, my lord. Until or unless, my lord, foundationally, if you do not have the evidence, you cannot arrest a person on mere suspicion. So therefore, my lord, kindly see, these are the grounds, my lord. My lord, kindly impose strict conditions. Because I fulfill, my lord, Satyendra Antil case, my lord, the 3 classifications, my lord. Therefore, my lord, I'll beseech, my lord, the poor fellow is in the incarceration for last 42 days, my lord. When the police, IO itself says that cooperating with the investigation.
So here the main accused, Tapik Gao, is on bail.
Correct, my lord.
Okay.
So many people, my lord, that paragraph 13, I
The
think.
present accused name is?
My name is June Lendo, my lord.
Okay. And no other accused persons?
No other accused person, my lord.
Have
6.
Not yet been arrested?
No, my lord. There are 6. There are 6 people in this particular case, my lord.
Yes.
Main accused is Tapigao, then director. Then I am one of the co-accused, my lord. Co-accused.
Okay.
And my wife is there. My wife name is there.
Okay.
I think Bengia Beti, huh? I think that
Yes,
case
okay.
which was, one Bengia Beti was there, then another some lawyer.
Okay. So
Yeah.
the
They are the beneficiaries, my lord. Another 4, they were appointed as PRTs or PGTs like that. So therefore, the police felt it necessary that these people need not be arrested. So therefore, my lord, the doctrine of parity will come into play because the main accused is already on bail in another case, my lord, on the same set of facts. my lord.
No, main accused is not.
Main accused is not-
Probably, it will not be. You can't compare probably because he was granted anticipatory, interim anticipatory bail on health ground because he was in the medical, showing his all documents.
Yes, my
So
lord.
not on merit.
No, my lord, that is why I say, for one reason, my lord. The reason is, for the one reason is that, my lord, the main accused is the Tapigao, my lord. He is the main accused. The court has granted bail on medical ground. Now, my lord, these subordinate officers, my lord, they don't have much role because they are not appointed to the authority, nor have a access or privy to the files where police decision can be taken, my lord. So therefore, my lord, just I beseech that there is really no requirement, my lord. My lord will kindly have the case very thoroughly and will pass appropriate order and also impose any conditions, my lord. Normally, in such cases, my lord, it is 50,000 bail bond. Normally. Well, this poor fellow will kindly allow.
He has a capacity.
Because the presumption is that this fellow must have done something wrong. The mistaken identity in a while making a window shopping in the castle of Chinatown. So that while making a window shopping in the castle of Chinatown, something might have gone distracted so that this thing has occurred. Then my lord will also peruse one more thing in the case diary, my lord. Whether the officer in charge of the SIC has given or given in writing and then communicate the reason of arrest of this accused. If it is not communicated, my lord, then my lord can always have a suo motu, habeas corpus petition directly, and then direct the release of the accused person, my lord.
Yes. Anything more?
No, no, no.
My lord, as far as the argument is, which my elder brother has submitted, my lord, regarding it being an economic offense and not his submission that he or she has not, taken any or made any loss to the state execution, my lord. My lord will kindly point out that, my lord, he was illegally appointed, number one, and he was in the service for the last 28 months, my lord. And when we calculate the amount which he has, his wife has accumulated in the 28 months is around 15 lakhs, my lord. It means there is a loss to the state execution, my lord. He says there is no loss to the state execution, my lord. But he has accumulated that amount, my lord, by illegally being appointed, my lord. And it is his wrongdoing that has made which has have made the state to lose those money, my lord.
For a custodial interrogation now.
So
that is the question, my lord.
the bail amount will be increased.
Yes.
Yeah,
You can increase the bail amount, my lord, no problem.
may I humbly pray that if, yes, he has been cooperating, we have taken his statement. He might not be required as of now in my humble submission. However, my lord, I will humbly pray that, my lord, if he is enlarged on bail, my lord, he should be given an strictness of the conditions, my lord. It is a fact that, my lord, he has accepted that he has illegally given money to the then director and appointed his wife, and he has in fact forged his own appointment order, my lord. So there are two sets of cases, my lord. So therefore, my lord,
Don't worry.
so that those things are not repeated, my lord. And 6 surety should be given, my lord.
Well, any conditions may kindly be imposed. And also make a special condition that if he is not required in any other case, so that they will have liberty to arrest me in another case.
I'll pass for that.
Grateful, beloved.
My lord, we return to CD, my lord.
So, after order.
My lord.
Yes.
For dictation.
Ah,
And
obliged.
today probably, I just want to complete, and today we have some, other work, interview to be conducted also, so probably
Okay, okay.
we may have to raise this.
That's why
My
our
lord.
bail item.
Obliged.
Yes. Yes.
Uh,
Yes.
Yes, my lord, during the pendency of this case, my lord, appellant died.
Mike,
During the pendency of this matter, my lord, the appellant died, my lord, dead.
Okay.
So, my lord, we need to file our substitution, my lord.
okay, Mr.
The other, my lord.
Lord Counsel for the petitioner, appellant.
Yes, yes, I am for that.
Lord Counsel for appellant, inform this court that during the pendency of this appeal, the appellant expired on,
My lord,
hence pray for allowing him to file the substitution petition, substitution of the appellant by illegal heirs. The prayer is allowed. List is matter after 4 weeks.
okay, ma'am.
Okay. You are for the respondent.
Yes, yes.
Good name
M. Khambo.
and a counsel for the respondent number. Sole respondent.
Yes.
Only, yes.
Sole respondent,
Sole
yes.
Okay, respondent is
Yes.
also present. Okay.
One of the cases is Deepak. This matter is being represented by Mrinal Kavita, one outstation lawyer. So matter will be fixed for hearing and matter will be admitted for hearing. It will come,
It was not yet been admitted.
not yet been admitted.
Not admitted yet, and your lordship, this is a long pending matter since 2020 it is pending, and
Regarding
pertains to this accused, your lordship. The investigation officer has taken leave for filing supplementary charge sheet because he's absconding as on that, your lordship. And NBW has already been issued. In this petition, they have,
absconding.
he's still absconding, your lord. Pertains to the other accused, the item number 3 will come to that. They were already arrested and against them charge sheet has already been filed. And it's fixed for CC, consideration of charge. But so far as the present applicant is concerned, he's absconding as on that.
So this application is for what then?
The,
Setting aside of the.
for
Setting
quash,
aside of
FIR,
proceeding.
yes.
While you are still absconding.
This is with regard to one, there is, main issue is, there is one non-bailable warrant as issued by the chief judicial magistrate concerned.
Okay,
That is why that is without jurisdiction, that is being silenced in this petition.
okay. So it should be issued by which court?
Chief judicial magistrate,
Ah.
and this petitioner was intending to take this anticipatory bail application. During the pendency of the
Anticipatory bail, you obtain anticipatory bail?
during the, no application, because no application can be filed when this non-bailable warrant of arrest is pending. This is the issue. Without any procedure, without compliance with the due process of law, the chief judicial magistrate concerned issued non-bailable warrant of arrest against the accused. That is the case. And in another case, there is.
How without jurisdiction? The CJM doesn't have a jurisdiction.
Lordship is aware of this, unless to my judgment. Unless to my judgment.
Yes.
When there is an accusation of 7 years, up to 7 years of, when final provisions up to 7 years, in that case, the duty of the court is to issue bailable warrant of arrest.
So straight away,
41A.
in the instant case, straight away, non-bailable was issued.
No,
Police is duty bound
For
to.
non-appearance.
Your lordship,
Yeah, non-appearance.
I will clarify one.
First, it should be.
I will clarify one thing, your lordship. So far as the other accused is concerned, charge sheet had been filed. So now, when charge sheet is filed, then it will come under the jurisdiction of the concerned magistrate. But here is a case pertains to this present applicant. He is still absconding.
So he did not appear before the IO.
Yes, Your Lordship. And
That's
yes,
different.
the issue is totally different. And prior to that also, Your Lordship, they have filed criminal petition challenging that NBW order.
Now since the conducting counsel is out of station, you said?
Out of, that is why matter may be admitted for hearing and there is no stay order in this case. Matter may be.
Whether the record was or no.
Record was,
Then how do, if he is still absconding, can we admit?
no, this what, if the council is not there, how, Your Lordship, matter will be admitted?
Problem. So let us pass the necessary order next time after hearing the party.
Yes,
So
sir.
for the time being, since you are praying for adjournment, will allow? Okay. Mr.
This is, I'm mentioning on behalf of Advocate Mrinal Kolita.
Okay. Submits that the conducting counsel, Mr. Minal Korita, is out of station. And pray for adjournment. Okay, he's out of station advocate, huh? And could not appear court today due to his personal difficulties. Hence pray for adjournment. The prayer is allowed. The prayer made by the land council for the appearing on behalf of the petitioner has not been objected to by landed ADPP, huh? Mr. Epe. Yeah. Additional public prosecutor.
Your complainant is also
The prayer is allowed. Complainant is also present. Okay, Miss Land council for appearing on behalf of the respondent number 2. Complainant is also present. Is prayed, come on, list this matter after
vacation.
after ensuing summer vacation.
Yes.
Okay.
This is a connected matter, that may be also.
Item 3, yeah? 3, okay, yes, it is connected. 3, okay. Yes. Okay. Yes, you are here as?
My lord, this petition has been filed by the state. my lord.
State.
There's no one from the respondent, my lord. This matter can be fixed after break. my lord.
So state file for what? This is regarding what?
We are challenging the order of the London Trial Court below, wherein the accused were partially discharged from certain offences during the framing of charges.
Okay,
So we are challenging that order.
okay.
But since,
They probably has filed Wakalat Nama
yes, my lord, their names has been reflected in the spouse list.
reflected in the cause list
Yes.
also. Okay, land council for. Okay, Mr. J. Sridin, land special PP, SIT. You are special PP, SIT
Yes,
there?
SIT.
Okay, is present, however, none appears on behalf of the respondent. In absence of the respondent, the case stands adjourned. List this matter after
Break, my lord. Summer
the
break.
summer break.
Obligation.
Yes,
Mayor, please.
yes,
This matter can be, my lord, examined today. Here in this case, my lord, we are challenging the impugned order dated 9/6/2023, my lord. That is at page 110. Wherein, my lord, learned special judge Poksho, my lord, Basa, without deriving any material on record, my lord. Attracting
Because my lord, we'll have to go through the depositions of the witnesses and other things, my lord. So therefore, my lord, let the paper book be prepared and my lord, let this matter come up for hearing immediately after the vacation, my lord.
the criminal revision.
Yes, revision, my lord. It is against an order, against an appellate order of the learned session judge UPA whereby the learned session judge has upheld the order of conviction awarded by the judicial magistrate in a negotiable instrument act case.
So
We had
paper book
already
is
deposited.
Paper book is necessary to prepare here.
My lord, it would be easy, my lord, for while we go for hearing, my lord, because there are depositions, there are 313 statements, there are impugned judgment. If there is a paper book, systematic paper book, my lord, it would be easy for the court also, my lord.
So let the paper book be prepared.
My lord, this issue requires only, this court has to decide whether the learned lower court has decided the issue in a right manner or not. So this case, there is nothing, since accused appellant was convicted by learned CGM under 130 Negotiable Instrument Act, then he goes to appeal to learned session court. Learned session court upheld the finding of the learned session CGM. Now issue is this court has to only peruse the records which is available with the courts since the LCR has been called. Whether the learned court below they have passed the order without apply the judicious mind. This both the learned CGM and session court have beautifully explained all interior regions. Now the 139.
Just scan copy or the original.
That I can say whether that is.
But my lord, this revision has to be admitted, my lord, because it is yet to be admitted. This revision needs to be admitted and it needs hearing, my lord, because I'll demonstrate before this court that the appellate court has not exercised the jurisdiction in terms of the law, my lord. Because I have checked the previous orders, my lord, this appeal is yet to be admitted. This revision is yet to be admitted. This may be admitted and posted for hearing, my lord. We'll finish it off on a hearing day, my lord.
So what is the you challenge the impugned order on what ground?
My lord, the impugned order is challenged. The impugned order is challenged primarily on the ground that there are contradictory findings by the learned appellate court. If I can straight away demonstrate two contradictory findings, and my lord, the learned appellate court has not appreciated any of the prosecution witnesses in a judgment which contains 32 pages, 23 pages only pertains to the submission of the counsel for the appellant and the counsel for the respondent. My lord will see, if your lordship kindly come to page number 52, page 74, para 52 of the judgment. Para 52, my lord will see. 52.
Yes.
Now, my lord will kindly come to the 1, 2, 3, 4. The fifth line from bottom, which start with on the right hand side, even for.
Yes.
Even for the said purpose, the evidence on behalf of the complainant could be relied upon. This observation was made. My lord may read the entire para. That will give an idea as to on what context this observation is made. The principle behind section 118A, that is presumption of the act, the court shall presume a negotiable instrument to be for consideration unless and until after considering the matter before it either believes that consideration does not exist or consider of the non-existence of consideration so probable that prudent man ought, under the circumstance of a particular case, to act upon the supposition that the consideration does not exist. This is important. While rebutting such presumption, what is needed is to raise a probable defense. Even for the said purpose, the evidence adduced on behalf of the complainant could be relied upon. Now, the next line is just opposite to what the learned judge has mentioned in the line just which I have read now. Now, the next line she says, however, in the instant case, the appellant accused miserably failed to rebut the presumption and failed to adduce any evidence in support of his defense. The accused is not required under the law to adduce evidence to rebut the presumption which has been rightly held on the previous line. Even for the said purpose, the evidence adduced on behalf of the complainant could be relied upon. Next line she says, since I did not adduce any evidence, therefore the presumption is upheld. This is one. Second thing, my lord will see. Now, my lord will kindly see page number 73. My lord is there at page 73?
73.
Yes. Yes, my lord will see. My lord will see. This is internal page number 23 of 32. That is total pages 30 to 23.
Yes.
Para 50, the issues are framed by the learned appellate court. Now the issue before this court is to examine as to whether the appellant accused raised probable defense to rebut the presumption in favor of the holder as provided under 139. Whether the appellant accused adduced any cogent evidence, whether the appellant accused able to show any evidence that a prudent man framed the issue. Now kindly see para 51. Without discussing any of the PWs, the learned court below comes to a finding. In the case in hand, the appellant accused not only fails to rebut the presumption in favor of the holder as provided under 139 of the Act, the initial barred line, she straightaway comes to a finding. I will demonstrate before your lordship, my lord, what is the parameter of an appeal. The learned appellate court, in fact, has assumed the role of a revisional court, which is evident from the observation made by the learned court at page para 56, page 75. Para 56, page 75, my lord will see.
Yes.
Page 75, para 56. The settled principle of law is that it is not for the revisional court to reanalyze and reinterpret the evidence on record. My lord, that is not. The court was exercising an appellate jurisdiction where the requirement is to appreciate and reappreciate evidence.
Appeal is a continuation of trial.
Absolutely, my lord. I am so deeply obliged, man. The appellate court has assumed the role of a revisional court.
So, probably this matter also requires detailed hearing.
Yes.
That is precisely what I was submitting.
Okay, heard Mr.
M. Biswas.
M. Biswas, learned counsel for the petitioner. So I've also heard Mr. Jitara, learned counsel for the respondent number. Others also hearing.
Only, I think, one respondent.
Okay.
Yes, no.
Miss, okay.
I'm for a one.
Okay. Mr. Hage, learned counsel, learned additional PP for the state of AP, and Mr. G. Tarak, learned counsel for the private respondent. Two staff. Upon consideration, the matter requires detailed hearing staff. Accordingly, let the matter be admitted. Let the matter be admitted. Staff. List.
On 27.
So paper book is required to be prepared.
I think
Probably there is a statement in the trial court.
Yes.
Statement 3-on-3, everything is there.
Yes.
Probably paper book may be required. Okay.
That will help the court also, my lord. That will even help the court also, my lord.
Okay. The registry shall prepare a paper book. So this paper book is prepared at the cost of the petitioner. Or what?
It's a
In a case.
appeal. It must be at the cost of the state, I think. It's appeal, criminal
At
appeal.
the cost of state, Miss Jenny.
Criminal appeal.
The paper book in the revision
Yes, Lordship.
at the cost of the state or
But registry will do the needful, Lordship. Registry will do.
okay. Paper book and furnish the copy each to the learning counsel for the parties. List this matter after preparation of paper book and furnishing a copy to the parties on the date to be fixed by the registry. After preparation only.
If
it
some
will be-
one
it-
date is given is,
No, date, because paper book, how long it will take, we do not know.
they will give 1 month time, within month it should be able.
Sometimes it happens that paper books, a lot of direction for preparation of paper book, they are limited staffs. So immediately after the preparation, normally they used to list only.
Yeah.
So they let that be fixed by the registry after completion of the preparation of paper book.
Otherwise,
Okay.
since there is stay order, my learned friend
Okay.
on several occasions in the agenda matter.
Okay.
It's a negotiable
No, no.
instrument. Yes.
Okay. In the meantime, that.
We had already paid more than 20% of the amount, my lord. We have already paid more than 20% of the amount.
Okay. The interim order pass earlier shall continue.
I'm deeply obliged.
Then, okay.
Obviously.
Yes.
Lordship, item number 16 may also be taken up, but similar matter arising.
7 and 16?
Yes, similar matters arising out of same case.
7 and 16.
16.
What is this matter about?
Lordship, this is an petition, Lordship. I filed an application under for praying for immunity petitioner under section 64A of NDPS Act and quashing and setting aside of the proceeding against the petitioner by invoking section 482 of the CRPC.
So what about this? The office note says the copy served.
Lordship, it was heard on the last occasion, and after hearing, Lordship was of the opinion that it should be listed on admission hearing, so it is here.
Okay. Okay. Admission hearing.
Yes, Lordship.
Yes, what was that?
Lordship, I'll give the brief facts first, Lordship, regarding the case. Lordship, during an investigation of a theft, during an investigation of a theft, a raid was conducted. During that raid, the petitioner, along with 2 other accused, were arrested, consuming cannabis, which was later on in the FSL, it was determined that it's ganja. And accordingly, they were arrested and was granted bail on, was arrested on 22/6/2023 and was granted bail on 28/6/2023. And your Lordship may kindly come to page number 64 is the bail order. Lordship, after the arrest, it was found that all of them were addict. And accordingly, on the prayer that they will undergo rehabilitation, the learned special judge NDPS was pleased to grant them bail on the condition that they will undergo rehabilitation. Lordship, in page number 65 is the condition where they have, it was in paragraph 3.
64, 65.
64, para 3.
Okay.
May I read, Lordship?
Yes, please.
It is discussed in bar that Mr. Sangetorji Thongji is suffering from multiple diseases, including rectal issues, which doctors find to be serious and unfit to kept in jail or police custody. This was because he was having withdrawal symptom at that time because of addiction. In respect of Pema Gandhi Pechupa and Toy Karpa, being addict will be admitted in de-addiction center, rehabilitation center. Mr. Bam Leonard Counsel for this has appraised that that well wishes of accused Toy Karpa had already paid costs for de-addiction program in Emmanuel Rehabilitation Center, Nahalagan. Also appraised that accused Prem Gandhi Pechupa will also be admitted in the same society. All the accused are young and waiting for opportunity. However, it indicates that caught carrying contraband weighing 355 grams, which is intermediate quantity. At that time, it was cannabis. That was cannabis, so it was determined that it was intermediate quantity. Later on, during the charge sheet, in FSL it was determined ganja, so it is small quantity now. So accordingly, they were released on bail. And accordingly, Lordship, the petitioner of item number 7 and item number 6, both of the petitioner underwent rehabilitation. I've annexed rehabilitation of in page number 66, where they have completed. Yes, he has completed his rehabilitation. He has underwent rehabilitation treatment for 45 days, whereas in item number 16, the petitioner has underwent 90 days of rehabilitation. Now, after that, item number 16, both are similar matter. Okay. The Lordship, consular note is there in the discharge slip, on the bottom of the discharge slip, where it's written, Sri Prem Khandu Pechulpa was admitted in our treatment center for treatment of his chemical dependency of ganja, has successfully completed his course in the therapeutic community and is being discharged today. That is so and so. Patient is suggested to follow by that. Lordship, he has successfully completed. That's why he has been discharged. And whereas there was 3 of them were arrested, 2 of them has successfully completed their rehabilitation and they have been discharged. Whereas 1 could not complete his rehabilitation as such, he could not get discharged.
He did not file petition.
Yes, okay. So now section 64A of NDPS Act, Lordship. Yes. Yes. Married. 64A. 64A. Married. Page 47. If it's the same barrack, then it's 47. No. It's not same, I think. It's different page. Yes. 64A. Yes. Married. Immunity from prosecution to addicts volunteering for treatment. Any addict who is charged with an offense punishable under section 27 or with offense involving small quantity of narcotic drugs or psychotropic substance who voluntarily seeks to undergo medical treatment for de-addiction from a hospital or an institution maintained or recognized by the government or a local authority and undergoes such treatment shall not be liable to prosecution under section 27 or under any other section for offense involving a small quantity of narcotic drugs or psychotropic substance. Not provided, there is also provided that the said immunity from prosecution may be withdrawn if the addict does not undergo the complete treatment for the addiction. Lordship, here in the instant case, it's relating to small quantity and section 27 only for consumption. They are nowhere involved in peddling. As such, section 64 can be invoked here. So now, what is the stage of the stage in the Lordship, for that also I have annexed the order, last order of the learned special judge, page number 60. Yes. Page number 63 will be the operating part. 63? Yes. Yes. Paragraph 17. Married. Yes. Therefore, on perusing the case records as submitted by the police under section 173 CRPC, this court is of firm opinion that there are grounds for presuming that the accused person have committed the offense. Hence, the accused person, Sangilorji Tongchi, Prem Khandu Pechulpa, and Toy Parbak are charged under section 20B2A, 27A of NDPS. And Lordship, upon being a so and so, para 9, para 20 is the next date, para 19 is issue someone to witness P1, witness PW1 and PW2.
Charge already framed.
This is,
At
charge
the-
frame?
At the time of framing charge, have you made an application for discharge?
Yes.
So that was not
It was
considered.
rejected.
Where is the rejection
In the
order?
same order, Lord.
Where? What is the justification given for rejection of the said application?
Lordship, para 14.
Yes.
In the instant case, the court found that the applicant have not annexed the discharge certificate of short courses, which is, there is no certificate or report from the concerned institute certifying that the applicant duly screened for substance of abuse which yielded negative result. This was the condition.
So this certificate,
Yes, sir.
which you have shown before this court, the annex of 5 page
Yes,
56, this was not there at that time.
This was there.
This was there
Lordship,
then.
The learned special judge was the opinion that there should be a blood test report should also be there. But section
Is that the requirement?
Section 64A doesn't say that. It only says it should, the rehabilitation should be completed. And according to the discharge slip, it's clear that he has completed. And for that, just, I will submit some authority from a.
So this, whether this Happy Life Foundation,
Yes,
Vision Foundation is
Yes,
the
sir.
government,
No, local authority. Local authority can also be recognized.
not the government, not the government institution.
No. It's either, it should be either hospital, either recognized by the government or local authority.
Whether this was is this the recognized one?
Yes, sir, recognized. In Arunachal, there is only 2 or 3 rehabilitation centers. One is Emmanuel, one is Happy Life.
How do you prove and so satisfy that this is government recognized institution?
Lordship, and in one, this is duly registered, properly registered institution, and registration number and everything.
Maybe. How do we, how do you satisfy the court that this is the recognized by the government? Registration, there may be so many registered association society, but then whether this is this a recognized one where the government in such circumstances or situation, they forwarded or forwarded the addict for the addiction.
Lordship, well, recognized means those who has been licensed by the government are definitely recognized. If it's not recognized, then license won't be provided.
Where do we find the license?
License number is on the top.
That is for what? What? For what?
For their rehabilitation center license number. I have the original with me also, if you Lordship want to
No,
purchase.
not the original. Where do we find that this rehabilitation, the recognized rehabilitation center? Where do we find that? Because anyone XYZ arrested under the same offense produced a discharge slip certificate obtained fraudulently or from the
Lordship, it's
institution which is not recognized by the government, then it will be difficult.
the Lordship, here there is 3 of them. 2 of them completed the rehabilitation as such they were
Yeah,
granted.
that is why,
Yes.
that is why. It should be a recognized one by the government, not by the anyone, any institution, any XYZ institution. Yes, Mr. Sirin. So what is your submission? So is this the recognized one by the government?
My lord, if we peruse 64A of the NDPS Act, my lord,
Yeah.
it says that medical treatment for de-addiction from a hospital or an institution maintained or recognized by the government
Yes,
or a local authority.
yes.
So there are 2-3
The
options. my lord.
local, that is also authority, see,
Yes, ma'am.
not by the local individuals. Local authority.
Yes, ma'am.
It has to be recognized by the government or the local authority is the government authority.
Yes,
again.
ma'am. But as
So
of now,
where-
my lord,
where-
unless and until if we rely on the license which has been given by the concerned authority, my lord.
No, the license
Otherwise,
for what? License for what?
license to run this rehabilitation
Where do
center.
we find that? That to run the
Otherwise, my lord,
rehabilitation center.
Happy Life Vision Foundation
Happy Lab visible, see, his name
But
can.
since the
everyone can
license
get, but
number.
in the license, it should be clearly, it should be revealed.
They have an original
Properly.
license.
This
Original
is
license.
certificate. This is, I think, discharge slip only.
Discharge
We do not know, the government must may be maintaining or may, maintaining the list of those institutions recognized by the government.
Yes, yes.
Where this such person can be forwarded by the court, by the NGOs, et cetera, from by the police. by
In
the
that way, my lord, in that case, a direction can be given to the Happy Life Vision Foundation to produce their documents, whether the
Yes.
foundation is
You
recognized,
have authorized
or not,
authority to
to run this rehabilitation
yes, yes,
as per
to
the
run the rehabilitation
yeah.
as per the government.
government norms.
So that satisfaction, if it is there, and probably you have a case. But otherwise you say, anyone XYZ, because there are a lot of cases.
And Lordship, in item number 16, in 16, I have went to the rehabilitation center directed by the court only, Emmanuel.
Directed by the court.
Yes, Emmanuel Rehabilitation Center.
Court on what basis it was directed?
Lordship,
It was maybe informed by you only, but then this court want to ensure that this is recognized. Because if you inform, and then court doesn't have, of course, the reason to disbelieve you. On your submission, probably might have directed, but then we want to confirm, because this will be the, again,
Yes,
DD case. Somebody will again come on the basis of this
Any-
order. So that way we need to ensure that these are the recognized ones, so that one, at least sentence should come.
Yes, ma'am.
So you satisfy that this is recognized one, and where the government can, it is a recognized one by the government or the local authority. So otherwise, this can be, so what is this? This authority is regarding what?
pair number 9, which clearly says that those who have underwent rehabilitation and
Yes, yes.
they should be granted immunity under the.
Yes, yes. So, you only satisfied that this is recognized one. And then you have undergone rehabilitation center being recognized by the government or the local authority. We'll pass over that.
Kindly pass over, then I will, after half an hour, I will.
Half an hour.
I will have a telephonically conference.
You have to produce.
Yes, I'll produce through WhatsApp. They can.
So today it may not be possible because today it's.
Time is already over. For-
So it has to be next day.
Done,
Yes.
sir, look.
So today is 26.
In that case, proceeding may be stayed for the both. Tomorrow is the date.
Let it proceed. Tomorrow is there for what?
For evidence, Lordship.
Evidence.
Yes, Lordship.
Let it be. If you are entitled, the court will pass order. Thereafter, it will be no proceeding. But then certainly today, even if no, have you made prayer?
For interim.
Because there are some other precedent, there are other accused
Interim
also.
prayer has been.
The other accused also.
Yes, one more accused.
One more accused. also.
Interim protection in respect of these two accused who are before my lord can be stayed for a time being, and then after vacation, this matter can
No,
be
no,
considered.
because since it will be only 1 day only, 1 day where you will not be adversely affected. Yes, but then if you are not, if you don't succeed, then you see, tomorrow the evidence will be recorded in respect of the present accused only, not against you. But then let it record. Okay,
That's
will not disturb that.
Kindly, it may be taken up tomorrow. Tomorrow I will provide.
No,
it.
tomorrow the list already prepared, not tomorrow. Would not exceed the list.
Twenty-
Prepared.
27.
One.
One. One.
First.
No. One is
Monday, July.
Monday. No, not on Monday. Monday, because hardly case will be listed, only few cases. will be
Then in
listed.
that case, 15th of July.
15 will list, 15 or 16, any date. Okay. Just a minute, this para 9.
Yes,
Just a few months. Only you produce those. Yeah. Okay. Mr. T. Gyatso, Land Council for the petition staff. Also have Mr. J. Siri, Land Public Prosecutor for the state of AP staff. If you file in the small form of affidavit, it will be additional document. Okay. Yes. Okay. As paid for Land Council for the petitioner, praise for allowing him, a praise for some time, as a praise for allowing him to file additional document with regards, additional, we'll say only additional documents. Okay. Okay, in the petition, in this terminal petition, staff on the prayer is allowed. Staff on para is prayed for by the Land Council for the petition of least this matter on 16th or 15th, no? 15 July. Both the matter. 15 probably, both the matter. Okay. 16 and 17. Similar matter.
Highly obliged.
7 and 16, huh? Okay.
Item number 8.
No one appears.
The one appearing in the online, you're for item number 8.
Oh, yes.
For item number 13.
Item
13.
13.
Item,
we are on item 8. No, this is 8.
Your Lordship, item number 8, even on the last occasion, none had appeared.
Okay.
We have also received the CD, Your Lordship.
In the beginning, the scan copy was not called for.
No, Your Lordship, this was with regard to the
Case diary.
case diary, Your Lordship.
Okay, thereafter subsequently it was found that case has been charge sheeted.
Charge sheeted, Your Lordship.
And then page what is the offense?
It's NDPS commercial quantity, Your Lordship.
Commercial.
Quantity, Your Lordship.
Difficult.
Yes, in fact, my prayer before Your Lordship is that take into consideration because CD was called for Your Lordship. Even if their absence is there, Your Lordship, instead of dismissing it on default, Your Lordship, can peruse the
yes.
CD
Yes.
and this.
No one appears on behalf of the petitioner. However, this is in Lanet additional PP, government of AP is present and produced the scanned copy of LCR.
The CD, Your Lordship.
CD, okay, CD. And I have produced the same stuff.
Your Lordship, the accused name is Sangarang Narzari. Sangarang Narzari. Sangarang Narzari, Your Lordship. I have flag marked his statement under 161 also, Your Lordship.
Where do we find?
I have flag marked it, Your Lordship.
Sangarang.
Yes.
Has he admitted?
Yes, admitted, Your Lordship.
Do you have the copy?
No, Your Lordship.
Why you have flagged this Rasidul Islam?
Rasidul Islam is the one, Your Lordship, who was in possession of the vehicle where the substance was recovered, Your Lordship.
And then Purpa Tasilangla.
He's also one who was to receive the substance from both the Rasidul Islam and the accused petitioner, Your
So
Lordship.
this Sangha Nursery is
He's a supplier, Your Lordship. He was also in the car, but then he has made a stop in particular place, and he had gone to the beyond this Chimpu, Your Lordship, was waiting for the Rasidul Islam. As soon as he saw that there was an interception and checking going on, Your Lordship, he had informed Rasidul Islam, and
then so chemical analysis is done.
yes,
Report received. Whether report received.
Your Lordship, since the charge sheet has been filed, Your Lordship, I have not been given with the
Charge sheet already filed.
Yes, charge sheet has already been
Okay.
filed.
Before that sentence, huh? Okay. Before case that goes, when you write one sentence, one more sentence, para, huh? Para, two. Write para number also. This is an application. And this is the bail application filed under section 439 of CRPC, praying for granting a regular bail to the accused. What is the name? Monga.
Sangarang Narzari.
Oh, see, Sangarang Narzari, who has been arrested.
Yes.
In connection with Doimo PS case number 67, 2023, under section 20,
C.
bracket C of C is also written of NDPS Act. By an order dated. Sorry, just right here. The case that is called for has been produced, and I have produced the same stuff. As per the report, the case has already been, the investigation of the case has already been completed. And the case has been submitted into charge sheet against the accused.
On 3/3/2024, Your Lordship.
On
3/3/2024, Your Lordship.
When this bail application was filed?
It was moved on 10/5/2024, Your Lordship.
So before moving, it was the case already charge sheeted.
No, Your Lordship, I might be wrong with the, I'll just check. But I have written it as 33, but then.
It's 3/3 only.
3/3 only, yes.
Yes, 3/3/24.
Yes, Your Lordship.
So case record was not called for.
He never called for, Your Lordship. Because even us, they had not annexed the charge sheet also, Your Lordship. And therefore, we had an apprehension that this matter was not charge sheeted.
No, probably on 12/6, there is a record call for the scanned copy of the trial court record.
Trial court record, Your Lordship. In fact, we got the CD because our last time Mr. Tado had appeared, he had called for the CD. In that case, Your Lordship.
Yes, okay, non-appears, huh?
No, yes, non-appearance.
Yes, no one appears on behalf of the petitioner. As per the,
On,
as per the records, the
yes, on,
petitioner remain absent on 12/6,
on,
2024 and 21/6/2024. And 21/6/2024 and today. However, Mr. Sorry, Mr. Genie, planning additional duty. State of AP is present staff.
Your Lordship,
Next is-
if I may just interfere, Your Lordship. On the first date, CD was called for on 10/5.
Yes, thereafter,
Thereafter,
subsequently, when it was reported,
it
that
was,
the case has been charged sheeted,
Yes.
thereafter scan copy.
Yes.
Staff, Ms. Jenny, Tommy is that she has a CD, there's a CD of the above PS case, number 6723. However, as per the order dated 12/6/2024, the scanned copy of the trial court record was called for. So, and she prays for some more time to produce the. scanned
no, Your
copy of
Lordship,
that.
the scan copy will be called by the registry, Your Lordship.
Okay. Okay, stop, In view of the above, however, the scanned copy of the scanned copy of the trial court record is yet to receive. Stop. In view of the above, the office to issue reminder for scanned copy of the trial court record. Stop. List this matter
After vacation, Your Lordship.
immediately after vacations. Okay.
Deeply obliged.
Return the CDs. Return, I think
We'll-
you
we'll-
retain it, and whether if the scanned copy doesn't come, we'll use this.
Yes.
If the petition doesn't come.
Yes,
Yeah.
yes, Your Lordship.
Because in that case, it's all the same.
All the same, Your Lordship.
Otherwise, all the same.
Yes.
Only that to fulfill the requirement.
Requirement, yes.
Yes. Yes, 13, 14.
Your Lordship.
Yes.
Your Lordship, in this matter, we have prayed to stay the complaint, case number, which was pending before the Honorable Court of
What is
Chief Judicial Magistrate
What is,
Bombila.
what is this case? What is this case about? Quashing petition?
Your Lordship, not Your Lordship, passing a particular order where the matter has been proceeded ex parte. Not ex parte, Your Lordship, the matter, the defense witness has been closed in the
Defense?
matter because of the defense witness has been closed by the learned Chief Judicial Magistrate Bombila.
LCR not yet received. Land Council? Have you taken
Yes, Your
steps upon?
Lordship.
Have you taken steps upon
Yes,
the
Your
respondent?
Lordship. Yes, Lordship. Even if this Honorable Court published the office
No,
note
no, not
also.
yet received.
It-
Not yet received. The LCR, sorry, the AD card in respect of respondent number 1 is still awaited, and also LCR not yet received. What you want
Yes,
to
Your
take
Lordship.
steps upon the respondent number 1?
Your Lordship, this is the sole respondent in this matter,
Yes.
and we have taken the step already. But
No,
in the IO,
AD card is still awaited.
Your Lordship, it has been returned as per the office note, Your Lordship,
No, no, office
and
note says.
which
No. If office note says AD card in respect of respondent number 1 not yet received, and scan
in the
copy of
IO, Your
this LCR is also still awaited. Miss,
Your Lordship,
you are Miss
and Deka, Your Lordship,
N. Deka,
Deka, yes, Your Lordship.
and counsel for the petitioner. The office note dated 22/2/24 and 4/5/24 reflect that the service upon the respondent number 1 and the LCR is still awaited. You want to take fresh steps or what?
Yes, Your Lordship. Your Lordship, I would like to point out one particular thing. On 22/3/24, Your Lordship, in the IA, in the Lordship, an office note has been mentioned that the answer notice in with respect to sole respondent with postal note refused return to sender has been received, and the yes that has been placed in the record, Your Lordship. The respondent has refused to receive the notice, Your Lordship, that has been sent by us, Your Lordship. Okay, in IA, Your Lordship.
No, sir, no.
22/3/24, Your Lordship.
Respect the sole respondent with postal note. You take, this was through postal, then you, post.
Yes, Your Lordship.
Take a step by dusty service. Has it been reflected?
Lordship.
Service number of sole respondent is not yet complete, no other as such, huh? You take a step by dusty service.
Your Lordship.
Because.
Yes, Lordship.
Okay. Just a minute, huh? Then this is in IA, huh? Hard, huh?
Your Lordship.
In view of the office note dated 22/3/2024 and 4/5/2024, the Learning Council for the petitioner prays for allowing her to take steps upon the respondent number, sole respondent by a dusty service. The prayer is allowed. The step be taken within
Your Lordship, kindly some 2 weeks, Your Lordship.
within 2 weeks.
2 weeks will be
From today, start, huh? The registry shall also issue reminder for LCR. Start, huh? List this matter after
Your Lord-
vacation.
Yes, Your Lordship. Your Lordship, kindly the matter can be maybe fixed on a particular date. Date may be
When do you
given, Your
want?
Lordship.
When do you want? When?
30th, end of Your Lordship,
When?
or first week of August, Your Lordship.
Okay.
As per
Okay. The list is prayed for by the Learning Council for the petitioner. List this matter on 6th August.
Your Lordship. Your Lordship, interim may be continued, Your Lordship.
Start, huh? The interim order passed earlier shall continue till the next date. Okay.
Decree of next, Your Lordship.